All right, Friday. Pam Bondi has a problem. 2.5 million files. That's not a typo. 2.5 million. And according to documents filed Wednesday in federal court, the Attorney General's office has been sitting on a discovery request for nearly a year, stalled it, delayed it, redirected it, and now we're getting a clearer picture of why. Because those files, at least as described in the court record, include communications referencing Trump family members, business dealings, internal memos, and financial transfers that investigators had already flagged back in 2024. I've been going through the filing since it hit. Hundreds of pages, multiple exhibits, privilege log entries that read like a roadmap. And what jumps out is this. This doesn't look like a simple backlog. This looks like a strategy. And quick note right up front, within the first minute, if you want these kinds of updates first, before they get watered down into headlines, subscribe to the channel and turn on notifications. The channel name is Everything OG. This story is moving fast and the next filing is expected in days, not weeks. Now here's the context, because the details matter. Pam Bondi is the current US Attorney General, appointed in January 2025. Former Florida Attorney General, a public figure with a long, well-documented history orbiting the Trump political universe going back years. The issue at the center of this, a Congressional Oversight Committee submitted a formal discovery request more than a year ago seeking communications between DOJ officials and Trump Organization-related entities. Requests like that are not rare. Oversight committees do this constantly. What is rare is what happened next. For months, almost nothing. Acknowledgement, vague reviewing scope language. Endless delay. Here's the timeline in the fast version. January last year, committee submits the request. April, DOJ acknowledges receipt and says it's reviewing scope. September, still reviewing. December, committee files a motion to compel. This month, the federal judge unseals the government's response. And that's where the 2.5 million number enters the record. And DOJ didn't say the documents don't exist. They said something else. They argued the materials are subject to executive privilege considerations and an ongoing classification review. Translation, in plain terms, we have them, and we're not turning them over. At least not yet. But here's what they didn't count on. The judge ordered a privilege log. That's not the documents themselves. It's the list, the inventory, a catalogue of what's being withheld, and the asserted reason for withholding it. That log is where the story lives. Because a privilege fight isn't just about yes or no. It's about what category the government claims and whether the category makes sense. And we're now about 2 minutes in, so here's your second reminder. Within 3 minutes, like you asked. If you want news updates like this first, subscribe to Everything OG and turn on notifications, because the key deadlines here are measured in hours and court business days, not in monthly news cycles. Now the documents, or more accurately, the descriptions of the documents, because at this stage we're talking about what the privilege log says exists, not what the public has been allowed to read. One entry, dated in the Wednesday filing, includes a description along the lines of communications regarding financial transfers between Trump Organization subsidiary accounts and consulting entities described as DOJ adjacent, spanning a time frame from late 2024 into early 2025. That's not commentary, that's the type of phrasing you see in privilege logs, broad, careful, and just specific enough to signal what's inside without revealing it. What does that imply? At minimum, it suggests DOJ personnel were handling, discussing, or receiving communications tied to money movement involving Trump business entities and outside consultants with some connection to DOJ work or DOJ-related matters during the transition period and into the new administration. Then there's another section described as family member correspondence marked as privileged. Tens of thousands of items in that bucket alone. Put those categories side by side and the question becomes unavoidable. Is this really about protecting executive deliberations, or is it about protecting particular individuals? And the pattern continues. In the log, communications involving Trump Organization entities are repeatedly flagged as privileged. A massive volume. Documents tied to Ivanka Trump-related consulting activity are described as pending national security or classification review. Jared Kushner-related Middle East investment correspondence is described as protected due to an ongoing investigation rationale. Eric Trump-related real estate items are described under third-party privacy. Now, I'm going to be careful here because this is where people can run ahead of the evidence. These are descriptions. They are not admissions of wrongdoing. A privilege log can be written in a way that sounds explosive and still ultimately reflect lawful withholding. But the scope is what's raising alarms, because buried deeper in the filing is what may be the real centerpiece, an internal memo, dated shortly after Bondi took office, describing a revised document, retention and special handling protocol. The memo introduces a new handling tier, described in the file as something like EPS, shorthand for Executive Protection Sensitive. And here's the problem. That designation is not widely recognized as a standard DOJ classification label. Not top secret, not confidential, not even the usual controlled unclassified information categories. As described, it reads like a custom category created for a specific purpose. According to the privilege log, an overwhelming percentage of the withheld materials fall under this EPS label. The bulk of the $2.5 million, the lion's share. If that's accurate, it means the dispute isn't simply some documents are privileged. It's that the government created or applied a new umbrella category and used it to cover most of what Congress asked for. The filing also describes internal emails about implementing the protocol. One email, attributed to a career DOJ attorney with their name redacted, raises an objection in writing, stating the categorization appears to have no statutory basis and recommending consultation with the Office of Legal Counsel before implementation. The alleged response from a supervisor, the direction came from the AG's office, and the protocol should be implemented as written. If that exchange is real and accurately presented, it matters for one reason. It speaks to intent and process, not politics, process. Whether legal counsel warned it was unsupported, and whether leadership pushed it through anyway, now the fallout is already starting to show in public moves. The House Oversight Committee has issued additional subpoenas. Senate Judiciary members are signaling preliminary inquiry activity. The Inspector General's office has acknowledged awareness of the filing, at least according to public reporting, while not committing to any formal investigation on the record. And then there's the number in the descriptions that grabbed everyone's attention. An aggregate transaction value described as roughly $1.7 billion tied to reference transfers, based on the privilege log descriptions alone, not the underlying documents, just the descriptions. That figure may later be clarified, disputed, reduced, contextualized, or reframed. But the mere presence of a figure that large inside a privilege log is why this story won't go away. And before we move on, I'll say this. If this breakdown is useful, subscribe. I'm going through the exhibits one by one this week, and the next round of filings is expected soon. When the Monday response hits, it will either stabilize this situation or blow it open. Now, to be fair, the other side has arguments, and pretending they don't exist would be lazy. DOJ defenders say this is standard executive privilege territory. They argue there's nothing inherently unusual about an attorney general asserting privilege over communications involving the president's family, especially where deliberative processes or sensitive interactions are involved. Some of that holds up. Executive privilege has been asserted by administrations of both parties for decades. It's not new, it's not exotic. Courts recognize it in certain circumstances. Second, they argue Trump family members can be private citizens in many contexts. Privacy rights exist. Not every communication that includes a family name automatically becomes legitimate oversight material. Third, they argue the 2.5 million number can be misleading because it may include duplicates, email threads, attachments, repeated chains, automated notices, and bulk document collections. The number can be huge even if the number of unique substantive records is far smaller. And DOJ's public-facing line, as we've seen in many similar disputes, is that the filing reflects protection of deliberative processes and lawful privilege assertions. That's the phrase you'll hear again and again because it's built for court. Also true, Supreme Court precedent leaves executive privilege broad in some respects, narrower in others, but not non-existent. Courts have sometimes upheld privacy protections for family-related materials in discovery contexts. And Congress can overreach. Oversight requests can absolutely become fishing expeditions. Even legal commentators who often defend executive authority will tell you this isn't automatically illegitimate. The real question is scope and motive. Not whether privilege can ever exist, but whether this particular use is defensible. So I'm not here to tell you this is definitely obstruction or this is definitely fine. The honest reading is this: there is a legally recognized framework that could justify withholding some materials, and there are red flags in the record that demand explanation. And the biggest red flag, as described in this filing, is the invented or non-standard EPS category, combined with the timing, a new classification-like tier applied to the majority of requested materials, created shortly after the Attorney General took office. Those are the facts being alleged in the court record. What they mean is the fight. Now the backstory that people are already bringing up because politics always backfills context. Bondi's Florida history is resurfacing. The Trump University-era timeline, the donation story, the controversy, the denials, the fact that no charges were filed, and the way critics say it established a pattern. Then the impeachment defense role. Then the 2024 nomination. During confirmation, questions about recusal, with answers framed around following ethics guidance rather than making an explicit commitment. None of that proves wrongdoing today, but it's why critics say independence concerns are not abstract. Now, Wednesday at 4:47 p.m. Eastern, here's the key judicial moment described. A federal judge issued an order essentially demanding a real explanation for the assertion of privilege over 2.5 million documents, using a category that, in the judge's view, required justification the court had not received. The judge compelled the privilege log quickly, on a tight timeline. That set off a chain reaction. The committee gets the log. News organizations prepare requests for underlying memos. Watchdogs circle, the story accelerates. But the part many people miss is what appears later in the exhibits. A sworn whistleblower declaration. The declarant is described as a career DOJ employee with direct knowledge of document handling procedures. According to the declaration, they raised concerns internally about the EPS category, were told to drop it, raised concerns again, were transferred, filed an internal complaint, got no action, and eventually contacted the Congressional Committee. That matters because it reframes the origin story. Instead of Congress went fishing, it becomes someone inside DOJ pushed this outward after internal channels failed, at least as alleged. And the most serious allegation attributed to that declaration is not that disclosure would harm national security, it's that certain documents could not be produced because they would be embarrassing to the family. If that quote is accurate, it's dynamite. Because embarrassment is not a recognized legal standard for classification or privilege. Embarrassment can be politically painful, but it isn't by itself a lawful basis to withhold records in the way the government is describing. And the judge, according to the order described, didn't just shrug. The judge reportedly demanded DOJ explain whether EPS was created to protect embarrassment rather than legitimate executive interests. A written response is due Monday. That's where this turns from a noisy political fight into a legal test. Because judges can tolerate politics, what they won't tolerate is a privilege claim that can't be defended within recognized legal doctrine. Legal experts quoted in commentary are lining up around one core point: creating a new classification-like category outside established frameworks is highly irregular. Another point: the privilege log descriptions, if they emphasize business relationships more than executive functions, raise serious questions about whether the withholding is properly tailored,